All right. So again, welcome out. We are talking today about Marbury versus Madison, which is one of the foundational cases in law school that we read and I'll admit, had no clue what it meant. I think it was the first case we read in law school, in constitutional law class anyways. And I was pretty clueless as to anything the teacher was talking about with it. And if you try and read the case, it's very difficult to do in the Old English of the time, trying to understand all that's going on. So before we get going, the goal with it today is to have discussion. We want to encourage open discussion. We do absolutely request that things stay civil and respectful. We do fully welcome opposing ideas. I'm not up here pretending to have all the answers. I believe strongly that we do best when we work together on these things. And then we just ask you to be truly open to learning from people. It's a great way to do things. Here's a quote I love about why to be informed. And it says, Americans' ignorance has become an entitlement to power for lying politicians. And because many Americans know little or nothing about the world beyond the U.S. border, their gullibility on foreign policy is boundless, and so is the president's power. This one is specifically talking about foreign policy, but it's one that when we don't know what's going on, we don't know what's going on. And people can tell us whatever they want and get away with it quite often. And so being informed is the first step in starting to exercise our rights, starting to work for things, starting to be responsible for our country. So going to Marbury versus Madison, does anyone in here profess to have a strong working knowledge of the case? Or even, I'd say, a remotely strong working knowledge of the case. It's a case that, again, it's kind of fun to think about. So I think what you have to imagine to yourself is, when we talk about Thomas Jefferson, maybe to apply it to our day, think about President Trump. It about fits the bill with how things went here. And so we have, in the young country, a pretty strong split, pretty right out the gate, of political parties. And John Adams and Thomas Jefferson were very opposed politically. They were very different in the things they believed and had a lot of contention among them. John Adams was the second president. When it comes time and he knows he's not going to be president anymore, he knows Jefferson's taking over, he says, oh no, this is horrible, what are we going to do? Well, let's make sure I put all the judges in that are possible. And so a little bit before he's supposed to leave office, he appoints a lot of new judges. It's a common thing we still see today, right? A lot of political power in the courts. And he appoints these judges. And so when he does, there's very little time left. It goes to the Senate. They approve the judges. And he has to ask his Secretary of State to help him get the commissions, they call them, the formal appointments to these judges. Well, a really funny thing at that time, it wouldn't happen nowadays. This is something that we've, grown or matured out of as a country. John Marshall, who was the Supreme Court Justice, he was appointed by Adams to be the Supreme Court Justice, Chief Justice, also served as the Secretary of State to John Adams. So we have one person sitting on the Supreme Court and one person is the Secretary of State. The reason the Secretary of State's important is because the law said that the Secretary of State held the seal of the United States. They were supposed to stamp these commissions for the judges and then deliver the commission to the judge. And so John Marshall, Chief Justice of the Supreme Court, has the job to run around, stamp everyone's commissions, get them in so that they're appointed as judges before Jefferson comes into office. Now, this happens, again, they call them the midnight judges, midnight packing of the court before Jefferson came in. He gets all of them but 4 done. So there's 4 justices that were appointed by John Adams, were approved by the Senate, even had their commissions signed and stamped, but he didn't get them delivered before midnight. And so Jefferson comes in the next day, he appoints James Madison, so Madison from Marbury versus Madison, as the new Secretary of State, and he tells Madison, don't you dare deliver those. We don't want those people, so don't let them in. And that's something that, again, if you think about President Trump, you can imagine with his personality saying, no way, we're not going to honor that, move on, we don't want that. That's what Jefferson was doing. And so Marbury was one of the 4 judges. He says, hey, this isn't right, this isn't fair. I need my judgeship because it was approved. I was appointed by the president. And new president, you don't have the power to revoke that. And so he files a lawsuit. Now, again, with this funny conflict of interest in place, if you're going to file a lawsuit and you get to kind of pick where you file at the time, where would you pick? Kind of makes sense that you'd think, I'm going to try the guy that was supposed to give it to me. And go tell him, hey, you got to tell the new guy to give that to me too. So he files directly in the Supreme Court. And we don't really hear about cases being filed directly in the Supreme Court today. There are still some cases that could be filed directly there. There was actually one a couple years ago they tried directly there, but the Supreme Court wouldn't take it. But he goes to the Supreme Court. Now, this puts the Supreme Court in a bind because Jefferson's very outspoken against the court. Jefferson was very opposed to the power of the judiciary, very opposed to the Supreme Court, didn't like a lot of what was going on there. And this is an area where the Founding Fathers didn't have a lot of agreement as to what the role of the courts were supposed to be. And so we have Thomas Jefferson over here. He's just spouting off about the court, saying all kinds of things. And if the court then says, oh yeah, Marbury, you don't have to. He doesn't have to deliver that. You don't have the judgeship. It looked to America like he was taking Jefferson's side. Like the court was, that they bowed to this political pressure. But if they went with Adams, he was just serving as the Secretary of State. It would look like this conflict of interest. And the thing to understand about this, the difficulty with it, is that it's a new nation. It's a whole new government trying to gain credibility in the eyes of the people, trying to get their feet off the ground, you could say. They're still trying to survive. They're not out of the woods yet, so to speak, when it comes to survival of the country. The other big issue was if the Supreme Court ordered James Madison to give the commissions to Marbury and the other 3, Jefferson had made it pretty clear he wasn't going to listen. So then again, what do? You're sitting there as a Supreme Court justice, you're looking through your options going, if I write this nice order, tell President Jefferson to deliver these, and President Jefferson says no, what do we do at that point? What does it do for the country? And that's a question, I think, that plagued these justices as they looked at this. They're staring at this going, wow, just out of the get-go again, we're here at this, what do we do? So I'm kind of curious, your thoughts at the start. What are some of your thoughts about the situation and maybe what you might consider doing or not consider doing? Just even regardless of what the law is, what do you think would be one of the good outcomes for America? Gopi?
I have a problem with this basic packing of the judges thing in the first place, which John Adams was even trying to do. The fact that that was even a possibility shows there's a problem.
Okay.
Or
so
the whole method of the appointment process, basically.
Okay. So we have this appointment. Now the interesting thing is, even though there was fierce divide politically, the Senate was really interesting for a very long time. I believe up until 1980 something, with I just forget his name. The first Chief Justice to get rejected by the Supreme or by the Senate. It might come to me soon. But for a very long time, regardless of the political party, it was almost a rubber stamp on presidential appointments. And it was no exception here. So John Marshall, for example, that was the Secretary of State, he was approved unanimously by the Senate. And so there was this check that was supposed to be in place on the appointment process. It wasn't really a thing. And for a long time in American history, they just approved, and it was more a formality. And then in the 80s, they had a Supreme Court justice who was finally rejected when it became highly political, and then since then it's gotten much more political. But to your point, is the appointment process great for judges? I'd say probably not. It's a lot of power for the president to have. Quick factoid, do you guys have any idea how many positions the president appoints currently? Anyone have any idea?
Directly or by proxy?
Meaning, in theory, it's the president that's appointed them. I'm sure he doesn't know this many people. But it's one where he has to appoint them and then they get confirmed by the Senate or put in. Some aren't confirmed by the Senate, but still put in by the president. There's a book you can look at. It's called the Plum Book. And it's the PLUM. It's the federal government puts out the Plum Book of positions. There's so many, the president obviously doesn't know enough people to fill them all. You can actually go apply to be appointed by the president for these positions in the Plum Book. But there's over 6,000 positions the president is now supposed to appoint and fill positions for during the term in office.
Those are mainly ones in the executive branch, right? Isn't that where that comes from?
So the answer is kind of. We have, what's really fueled the growth of it is the agencies. Agencies are technically under the executive branch, but constitutionally they're a mix of all three branches, the agencies are. And so he is appointing people to heads of the agencies, which have been put under the executive branch because they didn't want to amend the Constitution. But they are kind of a whole separate branch of government doing their own thing.
So 6,000 different agencies?
Well, so if you actually try, there's some fascinating stuff about this. If you look up how many laws exist in the federal government, the Library of Congress, you go to their website, it says, we get asked this question all the time, and we have no idea. They said no one has ever gone through and categorized all the laws the federal government has on books. Same with agencies. There is not a definitive list of how many federal agencies exist. It's pretty wild. And so, but the positions are for things, there's cabinet positions, there's judgeships, there's judicial, there's more than agencies involved in that, but yes, there's a lot.
So on your prior question, as far as Marbury Madison, I think it would make sense that it would go according to the law. I mean, I think the original idea was that, the government was of the people, by the people, for the people, and that the law would control. And so whatever the law says, that's what I think should be the outcome.
Okay, so they actually say that directly in here. They say this is a government by law. And if it's not going to be a government by law, then it won't ever work if we just start doing our own thing. But we'll still see how they said that, but still kind of did their own thing. Because one of the issues with the country at the start was the law wasn't super clear. There wasn't a lot of law to go around at the time. And so it is one of the questions of then, well, what do we do?
Just curious, when you mentioned that the Senate just approved everyone that was ever put forward up until recently, about the 80s, I guess. That's recently for me. But,
And that was the case at least with Supreme Court justices.
Yeah.
Maybe there was others, but...
I'm just curious as to it sounds like maybe they felt like at that time the justices weren't partial,
Well,
they were more concerned with the law than they were politics, whereas more today it seems like it's more of what side of the politics they're on.
So I had that view for a long time too, that maybe the judges were way better about what they were doing. But John Adams said, I'm going to put in my people to make life miserable for you, Jefferson, because I don't want your party to gain power. So I'm going, it's looking like they've been playing this game from the beginning almost with judges.
Yeah, I'm just curious why the Senate just rubber stamped everybody that came along.
I don't know, it's a real interesting thing to look at with the history of the Supreme Court justices and when it finally became a poll between the political parties as to who was appointed. So that is kind of a fun thing. But again, you're hearing this and you're going, man, think about if you were a brand new country and you had a President Trump and you were going to order him to do something. How would you feel as the court going, oh, is this going to work out? This probably isn't going to work. But legally speaking, it's very hard for him to say no because of the law in the place at the time did look like they should deliver, that they should have been appointed as judges. They were formally approved, everything was stamped. The only thing that didn't happen was they didn't get the paper delivered to them. That was literally the last step. So these are the three issues that Justice Marshall lists as controlling. And he goes through and talks about these three issues. Did Marbury have a right to his commission? Meaning, okay, is he supposed to get it, or could it be something that Jefferson could cancel? And did federal law then provide Marbury a remedy? So if he was supposed to get it, is the law going to give him something to do with that? And then the third is, did he come to the right court to ask for it? Because he filed directly in the Supreme Court. Was that proper? And to give a little bit more background on this, I think it was in the background section. I probably glossed over it. Let's see. There we go. There was a law passed in 1789. So the Constitution is signed in 1787, goes to the states for ratification. So one of the first Congresses is going, all right, we're going to start to put the stuff in place we need to. They were told by the Constitution to create rules and laws about the judiciary. They had to fill in a bunch of gaps with the judges. So they passed this law, 1789, and George Washington signs it. So I think that's a really important point to remember here with what Marshall does in this case. George Washington signs this law. So if you just think through that and say, okay, fresh out of Constitutional Convention, one of the first Congresses, we're here passing new laws. What's the chance you think they're passing unconstitutional laws in that Congress? I'd say chances are pretty slim, right? Washington signs it. And what this Judiciary Act of 1789 did is it said if you need a writ of mandamus, which is an order to a government official to do something, you can go directly to the Supreme Court for that. Because they said, we consider that pretty important. So just skip all the lower courts, go right to the Supreme Court. If there's a federal officer going off his rocker, go right to the Supreme Court, get an order to tell him what to do. So that's what Marbury did. He follows this Judiciary Act, and he files directly in the Supreme Court. But then Marshall throws in this question, well, are you in the right place? Yeah, the law said you could be here, but is that right? So one of the questions you want to think about as we go through this, and I think this is a very important thing to understand for our ability to understand how we play into the Constitution, how we influence what's happening in our nation and the places around us, is this question of, is the Constitution the supreme law of the land? And do any of you know what the Constitution actually says on that? It says directly in it. The Constitution says the Constitution is the supreme law of the land. But it also says, and we'll get into this in a minute, it's not necessarily applicable to this, but just a little nugget to know that's always been of some concern to me. It says the Constitution is the supreme law, and then laws made in furtherance of the Constitution essentially are supreme over state statutes and other things. And then it says treaties are the supreme law of the land. And it doesn't specifically say if the treaty has to be constitutional or not. But I'll show you that in a second. But we're going to really question, is the Constitution really the supreme law of the land? And look at some of what Marshall does here that sets the stage for almost everything we have constitutionally right now. So if we go to the Constitution, we have Article 3 sets up the judiciary, and it says the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. So Judiciary Act of 1789 starts to set these up. They create the district courts, the lower courts. And then it says, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made. So the judicial branch can hear cases covering all these things. There's some other ones they put in there. Now this is an important point to know for the case, these two terms. So the first term is original jurisdiction. It says where the Supreme Court has original jurisdiction. That's where the Supreme Court gets to act as the first court that hears the case. And so they list it as ambassadors, public ministers, and consuls, and those in which a state shall be a party. So if Colorado is suing Utah, that can be right in the Supreme Court. First case brought there. And then it says in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, which means it can only hear the case on appeal. They don't get to be the trier of fact. They're not the first case. They're not the first go around with it. But then it says in here, with such exceptions and under such regulations as the Congress shall make. So Congress in the Judicial Act of 1789 says, we're going to give the writ of mandamus another basis for original jurisdiction because we can have different exceptions, different rules. We can kind of move this around as we see fit. And they did that. And so, again, the legislature, executive branch looking at that. This is the Supreme Law of the Land Clause. And if you notice the grammar, this Constitution and the laws of the United States, which shall be made in pursuance thereof, semicolon, and all treaties made, or which shall be made, shall be the supreme law of the land. So just out of the get-go, can treaties trump the Constitution? It's an interesting question that I don't fully have an answer for, but I think there's an argument to say that treaties don't have to abide by the Constitution based on the grammar there. Others would say, no, the Constitution is listed first. It definitely needs to follow that. But little interesting tidbit. And then we know with the Constitution that if it's not specifically listed as a power, then the government's not supposed to have it. The federal government's not supposed to have it. So when we get into the judiciary and look at it and say, what can judges do? The Constitution never gave judges the express power to tell the legislative branch or the executive branch that a law was unconstitutional. It says here that they have the power to listen to constitutional cases, but it didn't say what they could do about it. And so this comes up in this Marbury versus Madison case, and it's an important point to know because it plays into what they do here. So looking at Marshall, he understands that this is a very complex decision, very important for America. And so he says the peculiar delicacy of this case, the novelty of some of its circumstances, and the real difficulty attending the points which occur in it require a complete exposition of the principles on which the opinion to be given by the court is founded. In other words, he says, I'm going to go into some things maybe that weren't fully raised because I think he's saying we want to keep America together. We don't want this to be something that starts to unravel where we're at as a country. So it goes on. He actually lists the law about the Secretary of State. The Secretary of State is told in the law to stamp and sign all commissions that come from the president. So it's kind of a shall thing. He doesn't get to choose this. So this is to the first issue of, did Marbury actually get a real commission or not? We won't go through all these things. But he's saying that he's acting as an officer in this when he stamped them. So this is Marshall saying, yeah, I was acting as an officer of the country. That was me stamping it. It was real. It was official. And then he goes into this interesting thing. And if those doors are locked, there is a little something we can put in there to keep it open. But he says, looking at all the law, actually giving them their commission, their stamp papers, he goes, that's not technically required. That's a custom. It's a practice we have. And so he goes on to find that the actual delivery wasn't necessary to make it official. So he says, it is therefore decidedly the opinion of the court. It's very clear this is the opinion of the court, which is his interpretation of law. That once the commission's been signed, the appointment made, so the Senate's approved it, and the seal of the United States is stamped on it, that it's valid, and it's good to go. And so then he kind of takes a stab at Jefferson. This is his chance to tell Jefferson he's in the wrong, and he says, the appointment is not revocable and cannot be annulled. It is conferred legal rights which cannot be resumed. So he's daring enough to put Jefferson in his place a little bit and say, no, you can't just cancel that. So what he's starting to do here is he's starting to show that he's tough, showing that he's putting the executive branch in its place, but he still knows if he ultimately orders Jefferson to give him the commission, that Jefferson won't. And so he's playing this really interesting dance right here of this. And so as you look at it, I think if you're him, you're going, what would make it so Jefferson would be willing to follow it? And if you're working with someone like Jefferson that's stubborn, that's opinionated, what makes someone like that willing to follow what you say? If you ever work with stubborn people, you what?
Something he wants, yeah.
Give him something he wants. And so what do you think Jefferson might want out of this? Any ideas? And it's okay to keep thinking on that as you go through. Because Marshall was playing this game too, as he was doing this. So he goes on to issue number 2. That is, okay, so it's a valid commission. You are validly appointed. You should have been a judge. Now he's asking, can the law do anything about it? Because guess what the law has not said in America yet? Hasn't said what happens if you don't get your commission delivered. There's no remedy stated in the law. It just said, oh yeah, you should do this, but then it doesn't say what happens. Now, Marbury is there asking the Supreme Court for this writ of mandamus, which is an order from the court to tell Jefferson, to tell Madison to give him the commission. Because if they get it, they can go then sit in the courtroom, be a judge. But he is going through and asking, well, does federal law give a remedy? Because nothing's listed. So to the point earlier, follow the law. This is one place they start struggling to say, what do? We don't have a specific law. So he quotes the laws of England, a settled and invariable principle in the laws of England, that every right, when withheld, must have a remedy. So he says, essentially, if there's a right granted by the law, there has to be a remedy, or else it's not a law. And that's a principle from England. So is that something you guys agree with? Disagree with?
Makes sense. What's the purpose of the law if you can't enforce it?
Okay. But then the question becomes, how? Who decides that? Because the Constitution broke up the lawmaking power into 3 branches, and the judges were to apply the law. If there's no remedy stated, then what do you do? And so they're starting to look at this. And so why does he refer to the laws of England? Again, this is the Constitution's supreme law of the land.
Maybe that's all they knew.
Okay, so they certainly knew the laws of England well. England had a very well-established set of precedent and code. But what else are they going for?
Jefferson probably respected the law.
Okay, so that would be a serious thing. Jefferson had great respect for it. What's he trying to establish kind of as a foundation for his decision? He's trying to appeal to something that people would respect, people would accept. Because if he just comes up and says, in my opinion, every right has a remedy, what's the chance of people adopting that? Or rejecting it? Chances are pretty good people choose to reject it. But when he says, laws of England, look, it's well settled here. He quotes Blackstone, I think, on the laws of England at this time, who was a very pronounced legal scholar. So what he's doing is he's now allowing credibility to be established, and the Constitution is starting to be shaped by appeals to outside sources of authority. And this is, again, an important thing to understand, because in Supreme Court precedent, they rely heavily on outside institutions of moral authority in setting a lot of what takes place. They always need an appeal to moral authority to make some of the decisions they do. And this is one of the places where we as a people have a lot of power over how the Constitution is shaped, is that it's not just the written words that are deciding things. There are institutions that shape the moral authority of our country. For 200 or so years, what have those institutions mainly been? Any idea? Churches. Churches have been the main shapers of moral authority in the United States. It's the Christian foundation that we were built on. And what's happening right now is that there's a very strong push to keep religion out of politics. Why is that? Because they want to replace the source of moral authority for constitutional interpretation. It's a very pronounced attack on our freedoms and on the Constitution, because if you can change the centers of moral authority, you can change the whole way that the Constitution is interpreted. And so, at the time, Marshall was appealing to the moral authority of the day and saying, we have England. We didn't like them. We rebelled against them. We left them even. But hey, we're going to use them as our moral authority because they did some things right, apparently. But there was respect for this. So now this is a really important point to think through when he says this in his second issue. The government of the United States has been emphatically termed a government of laws, so this was mentioned before, and not of men. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. So let's unpack this for a second. What is he talking about with this statement?
Probably the whims and fancies of men cannot be the way we do things.
Okay, so he's certainly saying we can't just go based on, new president decides something new. It can't just flip-flop back and forth.
Yeah.
New president in, everything out. He's certainly saying that. What else is he saying about the judiciary's power that he's starting to make a case for?
You'd be able to enforce the laws.
How?
They're the source of the remedy. They can define the remedy.
They can define the remedy. So if what he's saying right here, think about what he's saying. He's saying very strongly, a law that takes two parts. A law takes something written, a rule, and it takes a remedy. If you don't have both, there's no law. I think most of us would agree with that. In general, if you can't enforce, a human-made law, if I say, hey, it's the law that you can't speed and I can't do a single thing about those speeding, it's just words. And he's saying this goes down the drain at that point. But think about the power that he is starting to take here to the judiciary. The judiciary was specifically tasked by the Constitution as interpreting law. And he's now saying we can write half of it. It's a very strong pronouncement. Because he says, but he's saying too, if I don't go write the remedy, what's he saying will happen?
To become lawless.
We'll become lawless, the country will fall apart. Because at the point, once you get to this point where there was a law written, people relied on it, they show up in court, it's going to fall apart. So again, this is a guy looking at the country of 15, 16 years going, oh, this is not going to work if this is the case. So there's this expediency basis where he's going, to keep America alive, essentially I'm going to say the judiciary has the power to write half the law when it's not there.
So, remind me, there's three branches. The legislature was created to create laws.
Yep.
The judiciary was to interpret the law, and then
Yep.
the executive was to enforce the law.
Correct.
And here you have a president and executive who's not going to enforce the law.
Yes, and so this is a great point because this is something else he talks about. When we bring it up, it'll come up a little bit later. The president, the executive, is tasked with administering and enforcing the law as written. And Jefferson said, I don't care. What are you going to do about it? I've got the armies, navies, I've got the force. What are you going to do? And the legislature, they can pass laws, they can put words on paper, they can throw stuff out, but they don't really have power to do much about it either. But the courts, even more so, the legislature at least can give people money. They can pay people or not pay people. But the courts, what can they do? They have virtually no power to make or enforce anything. And so yes, the executive is supposed to enforce it. And so again, this is 15, 16 years in. Chief Justice is looking at this going, man, the executive's not doing his job. And he's told me we're just not going to do his job. What do we do to keep this country together? And again, this case is, this Chief Justice has been heralded as one of the most brilliant thinkers and solution solvers of the day, and at least addressing this problem. Now, he's also brilliant because he pulled a lot of power to the Supreme Court with what he did with this. But he is looking at this. And so, again, when you look at this, understanding that if he first articulates law is written, and there has to be a remedy, and if there's not, the whole thing's going to fall apart, so we're going to supply a remedy, which means we're going to step in and essentially write half of law. Now, it is a little different. It's not fair to say it's exactly half because they're not deciding what's regulated, but they get to decide what happens to those that violate things that are written. So then he brings up this thing about, he goes, but there's great danger in reviewing everything the executive does. And again, these are principles. He's starting to just go through tons of principles going, there's a lot at stake here, and so we're going to talk about it. But he is saying that can we review everything the executive does? And so then he goes into say, and again, these are little snippets taken. If you read the whole thing, it's long, it's hard to understand. But he says, if some acts be examinable by the court and others not, there must be some rule of law to guide the court. So again, we go to this thing about Constitution being the supreme law of the land. Is it really? What's guiding the court? And what guides the court today when they establish a principle or a rule? It's going back to these bases of moral authority that get established. And I know that Gopi works a lot with culture and looking at that and its role, and this would be, culture is one of the bases of moral authority that gets established, gets created, gets widely adopted. And he's going to appeal to a widespread notion to guide the court, and when they can review the president and when they can't. Now, why do you think he felt it important to go in and say when he can't tell Jefferson what to do? Because he knows Jefferson's personality, and he goes, I gotta let Jefferson know I'm not gonna come after him for everything. And so he goes through this question, which wasn't necessary to review in the case. And so he says that, I'm gonna tell you, Jefferson, by the Constitution of the United States, the President is invested with certain important political powers, in the exercise of which he is to use his own discretion, and is accountable only to his country and his political character and to his own conscience. To aid him in the performance of these duties, he is authorized to appoint certain officers who act by his authority and in conformity with his orders. So he's saying right here, when it's discretionary, when you have a choice as to what to do, it says no court can tell you what to do. He says in such cases, when it's discretionary, their acts are his acts. He's talking about the agents. And he goes on to say that the discretion may be used, and he says still there exists and can exist no power to control that discretion. So he's saying, I'm putting up a bounds and saying, hands off, courts aren't going to touch your discretion on things. And the subjects are political. They respect the nation, and they're entrusted to the executives. And then he goes on, puts this very strong line in, they can never be examined in court. And that today is still a very strong precedent. The courts have religiously followed this and said, we're not going to touch discretionary acts of the legislature, of the executive. If they get to choose, that's a political decision. They answer only to the people in an election. That's it. We won't touch it. Now, again, I think he felt he needed to say this and do this because he was worried about what Jefferson would do. And so he's trying to tell Jefferson, signaling to him, I'm not coming after you for everything. But then he goes on to say, and this is now a jab he takes at Jefferson, he says, but when the law commands you to do something and you have to do it, which is what they had to do with the appointments, they had to stamp them. That's what the law says. The law said you shall stamp them, you shall make that official. He says the president cannot at his discretion sport away the vested rights of others. So on one hand he's telling Jefferson, not coming after you, but slapping you the other way to say what you did was wrong. And again, he keeps taking these little jabs. And it's this thing where part of what he's doing in America is he's trying to assert his own authority to convince Americans that the Supreme Court knows what it's doing. And so he's trying to establish credibility in the eyes of all Americans. And one thing to know about this case is that it was widely held as one of the most amazing decisions ever. It was printed in most newspapers across the country, the full case for all Americans to read. And it was certainly something that was seen as helping America come to a place of comfort with the Supreme Court. And so think about this, asking this question, what is the principle, the foundational moral principle that would allow a court to insert a remedy when the law didn't specifically state a remedy? What principle would he be relying on? Any ideas on that?
I don't know necessarily, but he's referring to what the nature of a right is.
Okay.
If you have a right to something and that is violated, then if there is no remediation, I mean, that's why they're going back to the English law, regardless of whether it's England or not. The very essence of what a right is that you are what's the what?
There's a consequence.
Yeah. That you have to be awarded something as compensation, regardless of what that is for the particular circumstance. And just as a thought, I mean, it would be very hard to legislate in every single instance what a remedy should be, because all cases really are individual. So someone is going to have to come up at least with the details of the remedy for every particular case.
Okay, that's a great point. If it's to be individually applied, then there has to be some flexibility in that remedy, right? For sure. Do you have something?
When you're talking about principles, what, like in general, what, like I know when I hear of principles, like I think of limited government, popular sovereignty, separation of powers, checks and balances. Is that what you're thinking
Yep.
of? You're looking at?
Yeah, those are principles. So what principle is he appealing to? What's his moral basis to say? So certainly he's saying if there's a right, there has to be a remedy. But going one step beneath that is to say, but what principle is he relying on to say, so because that exists, I need to fill that role now?
I wrote my 7 down. I'm trying to think which one it would be. So it would be republicanism, because that's voting. It's not checks and balances.
Well, it could be a check and
It could
balance.
be checks and balances or separation of powers, but that's more in his previous decision. This one he's doing the remedy.
Yeah,
That's more of a judgment, right?
it
He's
is.
not
And
limiting government.
he's really expanding government, and he's even going to openly say that.
Yeah.
We're going to see that in a minute. He's going to say, I'm expanding the power of the judicial branch.
And federalism gives it to the states. It's
Yeah.
not passing it down to the states. So and last ones are popular sovereignty. I guess maybe it goes back to checks and balances and separation of power.
Okay. So you're saying there's a checks and balance basis, which I agree with,
Uh-huh.
but I think there's more.
I think he's saying it's only fair to have them.
So he's saying it's only fair to have a remedy if you're going to have a law. But again, even think a little bit deeper to say, but what's the moral basis for a law? What's he appealing to? Why do we even have moral authority to put law in place? Because he's saying this is so important that I need to step in and do something about it. Because there's a lot of shoulds in life. I can look at life and say, oh, they should have done that and they should have done that, but I don't do anything about it.
I mean, he's realizing the social reality that there's a power at play here, and someone has to hold it, or else it will just tear everything apart.
Okay, so there's the social reality. So he's looking at the options, kind of. They've just been through this Revolutionary War, and he's going, if I don't step in and take the power, what are the options? Where's it going to end up? And the social reality point of what if the moral basis he's looking at is purely preservation of the nation? Where he's just saying, if I don't do something, and Jefferson's in charge and he's not listening to us, this whole thing's going to fall apart. What happens if it falls apart? Chaos, bloodshed, all these things. And I think what he's appealing to is he's saying there is a moral basis to say that keeping order, keeping some semblance of community, keeping a basis of working together is more important. There's more of a moral right to that than it would be wrong to let it go the other way and let it devolve into nothing again. They watched the iteration with the Articles of Confederation. That didn't work out. They watched that result back to bloodshed, riots, revolts, all kinds of things in America. And I think what he's feeling here is there is a moral right for people to have a government and be able to work together. He's appealing to the very foundational basis of kind of what the founders appealed to, which is we have a right to be protected in certain ways from people, and it's a truth. It's one of these inalienable rights. It just exists. It is what it is. That he's really appealing, in my opinion, to truth right here, and he's just saying this, based on the pure reality of things, based on truth, is a better alternative than what we'd have otherwise.
So then I would say that that is an ideal
Okay?
and not a principle. So he's appealing to the ideal of liberty and he's democracy and the world working together as an ideal because it's a standard that can never be achieved but is always worked towards, right? So I would say, because then it's not just, I don't know, I would say it would be like that more, a morality is more of an ideal. It's like premier. It's steps above a principle, because a principle can be intacted, like in steps or in defined more concretely, where when you go to an ideal, it has a moral basis, it has a grander purpose where we strive to it, but we never achieve full liberty. We never achieve full, like the ideals, I don't know, lofty thought. Just.
Yeah, no, I certainly appreciate it, because one thing that happens is, I found this especially in law school, very many of us that had very many different definitions or understandings of the same terms. And when we talked, it was difficult to always understand where each person was coming from, because there were very different meanings attached based on where we grew up or the religious background we had or different things like that. And so I think it's very wise to point out to people that if the principle wasn't resonating, think about the ideal. He's appealing to this ideal. But even in the ideal, there's a moral authority in there somewhere to say the state is somehow better than what we had and where we're at. And so yes, it's a great point to make on terminology. And again, feel free to throw those out if there's better terms to use with these things. So here's a question for you. Is the judicial branch exercising legislative authority, lawmaking authority, when they define the remedy?
Seems to me that it happens all the time. I mean, what he said was you have individual situations, somebody sues somebody and the court decides the remedy. They say you get $5 million, you get $100,000. I mean, you can't go back to the legislature on every case and say, okay, what's the remedy for this person, what's the remedy for that person? Seems like those remedies are happening all the time in the courts.
So they certainly are, and there's individualized ones, but take a step back a little to say, could a judge say to Madison, you're going to go to jail if you don't deliver that? Could the judge say, oh, Madison, you didn't deliver that, so give him $1 million? The basis of whether you go to jail for something, whether you pay money for something, whether you're just ordered to do something, those are traditionally defined, I shouldn't say traditionally, those are often defined by the legislature. The legislature will say, if you speed, there'll be a ticket issued.
So, I mean, that's...
But the amount is kind of individual.
What is at that point you're coming to a question of like, what is actually fair in each individual circumstance? And what is the guide by which we determine this fairness?
Okay.
And it steps outside of law. Again, you're basically going back to whatever the social mores are, whatever the culture is indicating, like that these are the rules that we live by that aren't necessarily laws, but this is what we consider to be right.
Yeah, and we've watched, so one of the things we see is this evolution of money damages in cases getting higher and higher and higher, right? Where for a long time you couldn't sue for certain things. So for example, emotional distress, courts didn't allow that as a remedy for a very long time. They said, we're not going to go into the emotional realm, you don't get money for that, we're not touching it. But one day, a judge said, we progressed to the place as a society that we can award damages with enough certainty that we're going to move into the emotional realm. That was decided by a judge. And what that did when that judge made that decision is it opened up a huge new area of damages for people to seek to claim emotional distress for something. And so, yes, the courts are coming through and applying it individually. Now, what the legislature does, the courts actually recognize if the legislature steps in and tells us a different remedy, we have to listen to it. So, for example, one of the things that happens in criminal law is the legislature will come in and say, we're tired of judges letting people out. If you do this crime, it's a mandatory minimum of 15 years. The judge can't do anything less. And that does happen.
I think it's fascinating to watch, to go to watch the legislature and see what's being brought. And I think that as a constituency, that's where, you always want to say the squeaky wheel gets, but I've just observed, like, where the judicial branch is in session with the legislative, in the interim, when they're studying process, and they have to bring different reports to them, and they're telling them, this law is working, this law is not working in the juvenile justice system or in something. And so they try to communicate, but the most powerful thing is when a constituent comes to a legislator and says, this is the domino effect because of this law, and then getting a legislator to step in and look at it and get it changed because of the impact to a citizen. And that doesn't get very much visibility sometimes. And when you see youth and everyone, burning police cars or whatever, I should not say this, but you should burn your legislator's car, because your judicial is actually impacting the laws that those legislators made. It's not the judicial doing it, or your police have to follow this. It's really interesting. I feel like we really haven't taught our society enough of who's in charge of how it happens, and that sometimes they blame the wrong branch.
Okay, and that's a fascinating point to make. Why do we blame the wrong branch? What's happening?
You don't know. Your ignorance talk, right?
Okay,
Ignorance
so there's ignorance, but are there also people that intentionally push the blame somewhere else? We're actually going to see that in this case.
Interesting.
So I'm very grateful you brought that point up, because Marshall plays this card. And Marshall creates a villain, in this case, and blames the villain to resolve this. And it's a fascinating approach, and it's something that we're played on all the time here in our country. Smart people know how to play this game of creating a villain, blaming them, and it's not their fault, and we all focus there. And Marshall does that in this case.
I think there is also something to be said for the power of precedence, because the power of precedence is what makes it so that the same thing is done with everyone.
Okay?
So the fact that the judiciary is taking one decision and saying, okay, in this case, I'm giving this as the remedy. By the way, you guys, legislators, you have not looked at the remedy in this particular law, or you have not addressed it. So now I'm going to give this decision. I'm going to throw this back at you, by the way, put it top of your priority list, because it's coming straight from the Supreme Court. This will be the first thing you'll address in the next session and get this fixed. Because by putting me in this situation where I have to create a remedy out of thin air, it is showing a lack of you having made the law profitable.
Yep.
But if these, like you, example you just gave, the damages, emotional damages or whatever, the judge says that, and it becomes a thing, then that means the judge or the judiciary is working with the power of the legislature because of the precedence itself.
Yep.
So whether you call it the judiciary or not, it will not be fully the judiciary because it's coming with this legislative power.
Yep. Yeah, that's a good point to say that to this question of, are they exercising lawmaking authority? At times, absolutely. They absolutely are. And it's something that, again, Marshall steps into very quickly to say, ooh, if we don't, something bad's going to happen. And this is, and I actually think, so one thing to remember about this is I think it creates a false dichotomy where there's only one of two options. I do believe there were other solutions to this, possible. I don't know the full political scene of the day, so maybe it wasn't. But just from a principle perspective, I believe there were some other solutions. But he goes to this issue number 3. So now he's saying, hey, did you come to the right place? You're in the Supreme Court. Can we do anything about this? And yeah, the Judiciary Act of 1789 says we can. But what are we going to do? And so now he goes to this point that's kind of been there the whole time. He says, the subjects, so the subject of delivering the commission, the acts of Congress are silent. So what's he starting to do right now? he's starting to create this villain. And he's starting to say, guys, Congress is to blame here. They didn't tell us exactly what to do when there wasn't a commission delivered. It's not the president, because he's the one we have problems with. Congress is the problem here. And he says, oh, we've already said it's a vested legal right. Congress gave enough laws for that. And so then it goes on and he says he's got this right to the commission. And again, he's kind of going through this. But then he goes, but guys, guess what? Constitution said I only have original jurisdiction in a few certain areas, which means the case can only start here if it meets a few certain things. And he says, so you got to show me this is an exercise of appellate jurisdiction if I'm going to be here, because I can only exercise appellate jurisdiction over this type of case. Now the attorneys, Marbury's attorneys went, no, Corey, you're crazy. I said that the Act of 1789 says you can be here. They made it original jurisdiction. And he goes, that Constitution says I only have original jurisdiction in certain areas. Conveniently, in this whole case, he leaves out this whole line about the exceptions and the rules that Congress can make. Doesn't even reference it. Silent. And he says, I only have original jurisdiction over a few things. And so they start arguing about this, going, no, you've got original jurisdiction from the statute. And then the other side says, oh, that's right, Judge, I get where you're going. Hey, Judge, that statute's unconstitutional. Congress can't expand the power of the Constitution. And then the other side responds to that and says, Court, you have to do what the Constitution says. It never says you have the power to decide what's unconstitutional. So leave their argument alone. It's original jurisdiction. And the court's here playing this game. So then he goes into the same thing with this rights and remedy type thing. He says, oh, so what am I supposed to do as a judge when there's an unconstitutional law? So one side's telling me I can't touch it. I just got to follow it even though it's unconstitutional. And again, he creates this really nice dichotomy of, oh, it is or it isn't. And so he says, so does it operate as law if it violates the Constitution? And again, remember, he's talking now about one of the first Congresses, George Washington, these big founding fathers signing an unconstitutional law. Think about what he's doing here. And so then he says, it is emphatically the province and duty of the judicial department to say what the law is. So he's making this firm statement. This is our job. We say what the law is. And then he says, so what do we do when two laws conflict? When two laws conflict, the courts must decide on the operation of each. So the question then, is that true? Is that a true statement that the courts must decide? So think about it. The legislature, this happens often. They try to not let it happen, but it does. The legislature passes a law. Years later, they pass another one. The two conflict. Does the court have to decide what happens in that scenario? Could the court kick it back to the legislature and say, hey, you passed two conflicting laws, which one controls?
I mean, you could have a situation which, I mean, it's conceivable to have a case where you're just going to have, regardless of whether it's, laws that are made by the legislature, but just you will have what you would think of as two natural rights coming into conflict.
Yep, and that will happen.
Yeah. In which case, it would have to be the judge. That is.
But why does it have to be the judge? Why can't the legislature decide which of the two natural rights comes out?
Because the number of instances is not, it's not limited, it's not set.
For sure, but let's say that it comes up in front of the judge goes, oh yeah, two conflicts. What if they kick it over to the legislature at that point and say, tell me which one controls?
I mean,
or you can say, both these laws are void right now, go back, do it again.
Potentially, that gets into the problem of maybe someone relied on something and then there was no remedy and the system starts to fall apart, like he's kind of worried about. That could be a proper response in some cases, but in some, is he honest in saying it has to be the judicial branch that decides this? Because the Constitution made the legislature the lawmaking branch. And so could the judiciary respect that and say, we're just going to send it back, you tell me which one controls, it comes back.
I mean, if they don't do that, they'll be doing only the cleanup job after the legislature. The legislature can throw in any hodgepodge set of laws, and their half their job would be to, make sure all the laws.
Make sure it works.
I think the key word there is must. I mean, he's basically saying there's no other remedy except for the courts, and you're saying it's the possibility of the legislature to fix it, and maybe they shouldn't because they're lawmaking. So, I mean, maybe the courts could decide, but the word must doesn't leave any option.
Yeah, it doesn't. And again, this is kind of where he's really taking a stance and saying, we're going to take some ground here. And he's really driving this home to say, we're taking some ground. And that's why he says it's emphatically our duty to interpret the law. The only way to do that is to decide the conflict between two laws. And we go, I think there's an error there on the has to. Because even the example I gave, there could be other possibilities too. So then he says, so if a law is in opposition to the Constitution, the court must either decide that case conformably to the law, disregarding the Constitution, or conformably to the Constitution, disregarding the law. This is the very essence of judicial duty. So he's saying we have to interpret the Constitution, and he's saying we have to be the final say on it. Now this is the piece where the founders disagreed extensively and never put in the Constitution which branch was the final say. They never said that in the Constitution. Because the branch that had final say, if they would have openly put out to the group of founding fathers, this branch has final say, there would have been an uproar. People wouldn't have gone with that. They never agreed on who had the final say in anything. It was supposed to be a check and balance system, not a final say system. But again, he's looking at it going, oh, this is tough. We've got these things. And so he says, we can't close our eyes to the Constitution. We have to see the Constitution. He actually says in here, we take an oath of office to the Constitution. I can't close my eyes and not follow the Constitution. I'm going to do it. Now, what's the thing that he's missing? Or I think he knows this. What's the thing he doesn't tell us in that? When he says, we as judges take an oath to uphold the Constitution. Who else takes an oath to uphold the Constitution? All the other leaders do. So the legislative branch does. The executive branch does. They can't close their eyes to the Constitution. Did George Washington close his eyes to the Constitution when he signed this act? That's what he's inferring right now. And he's saying, as the judges, we're the only people that will follow our oath and really watch this. Interesting assertion. But again, it's a powerful argument. And now this is really where he gets into this villain thing with the legislature. Turns the problem to them. He says, it would be giving to the legislature, so he's saying if we can't declare something unconstitutional, he says it would be giving to the legislature a practical and real omnipotence with the same breath which professes to restrict their powers within narrow limits. He says if we don't strike down what the legislature does, they will be omnipotent. Again, what's the silent piece there?
We are omnipotent.
We are omnipotent. We have the power. And not quite, because they can't fully write every law they want to. But they're going to hold themselves up as a very high body of power. And again, he's creating the villain, saying, ooh, you don't want to trust these guys. you know there's someone in there you don't like. Can you imagine them just being able to tell you what to do? Not good. And this is something that, again, is very persuasive when he creates this villain thing. And this is something, again, that happens to us today. It happens often where powers that be that are smart create the villains. And so then he says, if we don't take this power, if we don't do this, it reduces to nothing what we have deemed the greatest improvement on political institutions, a written constitution. And then he says, the judicial power of the United States is extended to all cases arising under the Constitution. It says, we are taking the power of judicial review, and we're doing it very assertively, very strongly. And when he did that, what he did is he said, the Judicial Act of 1789 is unconstitutional. It expands our original jurisdiction, and it can't do that. So he put on this show where he told America, oh, Congress tried to give us power. They can't do that. I'm going to be a good guy and turn that down. It's unconstitutional. I don't have the power to hear this case. Think about that irony in that. He just went through this whole decision, issued all these opinions, and then at the end says, oh, but shoot, I don't have the power to hear this case. If you don't have the power to hear a case, you should just say, I don't have the power to hear this case. But that's not what he did. Now again, I actually believe in this there was great inspiration to what he did. I believe it was actually a very important case in holding America together and keeping the things going. But it is incredible to look at the irony of some of the statements to say, that act's unconstitutional. Because that act's unconstitutional, Marbury, you can't be in here asking us for anything. We can't issue a writ of mandamus. Sorry. And so it's this fascinating approach where he goes through this case, slaps Jefferson around, says, oh, you can't do that. You can't sport away vested rights. You can't do these things. But I know you're not going to listen to me. So I'm going to say, oh, but I don't have the power to tell you what to do. And I'm going to, though, say that I have the power to determine everything constitutionally. So America, I look really good because I've just walked away from power. I've turned it down, said, no, Congress, you can't do that. And makes the Supreme Court almost omnipotent. There's no check on the Supreme Court at this point with this way that this rolls out. Now with this, though, it's really interesting to think about. Sorry, I just lost my thought there. So we'll come back to it when it comes back to me. But the Constitution never said what to do when something was unconstitutional. So if the legislature passed an unconstitutional law, the president signs an unconstitutional law, they never said what was supposed to happen. But, and that's one of the points he makes. He's going, oh, we just can't let this go unchecked. But again, he leaves out this thing of, but what do we do in the judicial branch? Does something unconstitutional? He doesn't answer that for us, doesn't ask the question either. Again, just kind of puts the villain there. And he was very good about not making Jefferson the villain in this. He points to the legislature on it as being the fault and the problem. But going to this question here of what did he do here that made Jefferson and all future presidents accept what just happened? No legislature came back and tried to take this power back. No president came back and tried to check and balance this. Everyone accepted it. And what do you think, if you're looking at this, why is it that everyone in America would go, yeah, we agree, that's a good decision? There's a principle that the courts recognize very well and understand very well about what this is. And Justice Roberts, Chief Justice Roberts, quoted this in the Obergefell versus Hodges case, which was the gay marriage decision. He says, "This court only has power if people give our decisions respect." It's the sole basis of the Supreme Court's power. They have nothing constitutionally to enforce anything, to do anything. The only way they have power in the minds of any American in what we do, say in the government, is they are viewed as the wisest body of people. And their sole power extends from that. And so what Justice Marshall did in this case is he made himself look like the smartest person in the room. And no one saw anything wiser or better, and they all accepted it and followed.
So does that mean that today we're in the same situation, that really their decisions rest on how much credence we give them, that there's no way to force a president or someone else to respect or do what they say? Is that true?
It's the exact same situation today. So if President Trump came into office and said, "I don't care," there is no force in the United States currently that can do anything about it. And this is a point that I feel is very important for us to understand when we look at what people are doing, what the powers that be are doing to try and destroy the Constitution, to try and destroy our government. They're trying to break down the respect accorded to the Supreme Court. Because if that can be broken down, the whole checks and balance system goes into an intense state of disrepair, really starts to break down. Once the president decides, "I don't care." There's been a couple governors that have tried throughout American history to say, "I don't care." And there was actually, it's a pretty amazing story if you read the Brown versus Board of Education case when the Supreme Court said we have to stop separate but equal. And black students have to be allowed in with white students. Arkansas said, "No way, not doing it." The governor said, "No way, not doing it. We're not letting black students in with white students." Said, "We don't care what the Supreme Court says, we have state rights, we're not listening." And so the President of the United States had to send in federal troops to literally go to the schools and stand guard because people would go and form chains around the schools, human chains, to not let black students in. And so these federal guards come. And I think some of the most unspoken heroes in history probably have to be these few kids that went to these white schools. And there was one school where there was only something like 6 black kids that dared to go in because of how much oppression, hatred, violence, bullying, whatever there was. And these 6 kids went, accompanied by federal guards, to school daily. To be in these schools and endured all the onslaught of stuff as they worked to break through this separate but equal notion that was so intensely held. And I just look at those kids and go, where do you find kids with that much power? That's amazing fortitude to stand up against that and do that.
We do have, though, the holdings of the courts get enforced by the executive with the police power. I mean, that's what your example is, right?
Yeah, so but this is where the president had to bring in federal troops to enforce it against the state.
Yeah, but even in the local courts, I mean, if you don't obey a court order, the police are going to come and hold you in contempt of court or put you in jail.
Correct. But what if the governor said, "Don't"? Or we have situations where the sheriff says, "I'm not going to do that."
Right, it has to be, so you have to have that respect for the court all the way from the top.
Correct.
Right.
Yep.
And then those who follow them and follow orders and that kind of thing.
Yep. But it is one where if the local sheriff says, "I'm not going to enforce it," it's a little bit risky for the local sheriff because there's a state level that can come in with some police force. the federal government can come in. But if the president decides, I'm not going to do anything about it, there's no state that has the power to go force the president to do anything. They can't bring in their police force and make the president do something.
So what's the new thing in Texas right now where they are going to build a wall, even though the federal government, there was something just in the last month with Texas saying, we're going to do
Yeah,
this.
so
And it's kind of exactly the same thing that you're talking about,
So
right?
it's a great question. Texas says we're going to build the wall. Federal law says we can't. Texas says we're going to. Now, this isn't quite a Supreme Court order to Texas, but it is Texas saying we're not going to follow federal law. And so now Biden's in the position of, am I going to walk in and enforce federal law against Texas, or am I just going to leave it alone? And this goes back to the oath of office. We swore to uphold the laws of the land, the Constitution. What was Biden's response? Shocked all Democrats. Biden said, I'm going to waive enforcement of 26 federal laws so that Texas can build that wall. And so President Biden says, I'm not going to touch those laws. We're not going to come enforce it. Texas, you got to do whatever you want to do. So what if a president said that with the Supreme Court?
Right?
Yeah. Yep. So Texas is building right now. But this is a game that's starting to be played where they're starting to say, let's just not enforce it. What did California do with the gay marriage decision? California Attorney General said, yeah, we have a constitutional amendment that says marriage is between a man and a woman. And what they said, we're not going to defend it in court. The Attorney General has the duty to defend state laws in court. And they said, I don't care, not going to defend it in court. So you walk into court, you have the people suing California to say the law is unconstitutional. It says marriage between a man and a woman. And there's no party there to defend it. Literally. And so all these groups jump in and say, whoa, 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 we've got a court, hear us, let us have our case heard. And ultimately, do you know what the court said of whether other people could step in for California? It said no. We're not going to let other people jump in for California. If California doesn't want to enforce it, that's on them. And there was no party to defend the amendment in court in the California case. So the executive branch has started to make these decisions, and it's a play that sanctuary cities come from, where they'll say, oh, you can come here, we want to enforce federal law. Or they say, oh, come here, we won't enforce federal gun laws. Utah last legislative session had a bill that said, we're going to mandate that no Utah executive officer enforces any federal gun laws at all. We're just going to stop enforcing it, make Utah a gun sanctuary. And this game's starting to be played aggressively. But again, what is it doing? It's totally destroying the whole system our government's built on, the system of respect. And the Supreme Court, the politicalization of it, the fighting between them, is breaking down the credibility of the court. And when the credibility of the court falls to a certain level, at some point the president's going to say, I don't care. And this whole system is going to start to radically unravel at that point. And so the things that we need to be aware of in this, we need to be very aware that our job as a people is to really promote respect. We may not always agree with the president, we may not always agree with the Supreme Court, but when we talk about the supreme law of the land, the Constitution is not actually the supreme law of the land in all respects. The only way to have liberty, I don't know if you've ever seen the scale where anarchy's over here, tyranny's over here, and liberty's in the middle. The only way to have liberty is to pull ourselves out of anarchy, but keep ourselves from tyranny. The thing that pulls us out of anarchy is law. The thing that keeps us from tyranny is morality. And the Constitution was an adoption of law, but also an adoption of moral authority, of moral basis that kept us from tyranny. And the supreme law of the land has always been a balance between the two. And in these discussions that we go through, we're going to go through extensively and talk about different cases to show you where the Supreme Court's very express. They allow the Constitution, the written text of the Constitution, to be violated because there's a moral purpose behind it that they feel justifies violating the Constitution. In other words, they're saying there's something bigger at play here than the Constitution itself. And we as a people, the things that we say, the things that we do, the things that we speak, are what sets this moral basis and moral authority. And the things that we say as a people directly impact the moral centers, the moral powers that exist. At the Constitution Day event we did last month, we talked about religion and these claims right now that religion's a form of brainwashing. If you go try and find people's response to that, it's virtually silent. We're not responding to these claims being put out that religion's a form of brainwashing. There's no moral authority speaking right now explaining why religion is consensual, explaining why it's a good thing, explaining what's going on. It's silence. So when the courts have to fill in the void and they have to appeal to a moral authority, there's nothing to appeal to. And the moral authority, the moral basis that exists is the voices speaking. And so anywhere in written scripture, if you look, there's almost always the command to speak, to share truth. Because we live in a country where the things that we say literally shape our laws. It's very powerful. And we all have a duty incumbent on us to speak, to talk, to share truths. Because if we don't, these moral powers, these moral centers go away. And when they do, they're either replaced with law or a different moral code that then radically alters how things are interpreted and done. And so the takeaway, big takeaway, is we have the potential to be moral influences and moral centers. We can do that in our own little community. We can do that with our people we know. We can post things online. We don't have to condemn people. We don't have to say bad things about people. But we do have to be very strong in articulating and defending and putting forth a case for morality. And the morality that should govern this nation. It's part of who we are and what we are. And to me, this case is a big example of it. Chief Justice Marshall says, yep, there's a lot we're appealing to here. Yep, we're going to these ideals, these principles, these other things. And this is one of the things we're shooting for. And it's interesting, just one last quote from Scalia, since Scalia's always got a bunch of funny things to say. This is also from the gay marriage decision. He says, it is of overwhelming importance, however, and this goes to the point about the judiciary starting to become omnipotent, who it is that rules me. Today's decree says that my ruler, and the ruler of 320 million Americans coast to coast, is a majority of the 9 lawyers on the Supreme Court. This practice of constitutional revision by an unelected committee of 9, always accompanied, as it is today, by extravagant praise of liberty, robs the people of the most important liberty they asserted in the Declaration of Independence and won in the Revolution of 1776, the freedom to govern themselves. So Scalia is looking back and kind of going, oh, this power that Marshall created, it's the ruler today. It's making big decisions that impact all Americans, circumventing this political process. I personally believe there are things we can do to create checks and balances to the Supreme Court, to bring it back into a proper, healthy realm. And I really hope that you guys will actively consider, talk about, how do we get it to a good place of appropriate balance? How do we create a system, the reality of which works? Maybe there does need to be a final place somewhere. But how do we get a better system and process to select these people? How do we get a better oath of office to be followed? How do we make it less political in nature, where it's not just party-based? I believe there are solutions to all those things, and it's up to us to talk about it, to work on it. Because ultimately, I strongly believe, we have this here, this nation shall endure. Ezra Taft Benson, who was a strong political guru, religious leader, he wrote a book called that. He very much believed that. And we have the power as people to radically shape this country. So I don't know if any of you have closing thoughts, questions, things you want to share. We can talk about those right now if you want. If any of you have anything.
Just a question, so what's kind of the thoughts going forward? Is there like a different case or a different topic, or what's coming to big thoughts?
Yeah, so great point. Thanks for bringing that up. So my goal is to start to do this often. I don't have an exact schedule. The holidays are coming. But the next one we'll do is November 9th. It's a Thursday, the same location, at 6:30. If you want to make sure you get emails about it, put your name there so we are for sure to email those to you if you haven't already told me you want them. And then we'll just go. There's so much to the Constitution, so many things to unpack, so many cases. I think it's super fun to go through cases. Some reviews we may do multiple cases that aren't as impactful as this one. Some we'll look at in great depth. This gay marriage decision is actually a fascinating one to review, just regardless of what you feel about it. It's fascinating to see how the court did things, their arguments for and against it, kind of the power play that took place with it, the shift in some of the course of law. And I'm very open to taking input from you guys on which cases or topics you'd like to hear first, or we'll just start going through the Constitution in order, really delving into it. And we will go like that. We'll probably start to hold some online as well. There's a lot of people that can't come in person or that live outside Utah. And we'll try and have a mix of things that we do that way. But again, thank you so much. You have a thought or question?
Just the outcome, so I guess Jefferson said, okay, everything's fine.
Yep, Jefferson said, didn't have to deliver that. Sweet. So again, going back to what would make Jefferson follow this, they gave him something he wanted. They didn't make him give him, or they didn't tell him to give him the commission. These 4 guys never got their judgeship. And so again, there's this irony to it because, again, just look at the whole thing of, oh yeah, the law gave you the right, the law said you have it. The law even provides a remedy, but oh shoot, not really, because we won't do anything about it.
Yeah, his ruling strikes me as politically brilliant, but not right.
Yeah, and so it is one of those things where it was very politically brilliant. And Marshall had never been a judge before this. He was unanimously selected or approved by the Senate, never been a judge before, and pulls this off. So very ingenious for sure.
And when you were asking why it was accepted, granted I don't have my finger totally on the pulse of like all the feelings and the mindsets involved of everyone back then, but it would seem to me that they would respect in this instance the political brilliance.
Yep.
And that it makes things work. And that's why it was accepted at the time, regardless of how, because when you're looking at it logically, it's obvious that you're playing with the system. You step forward and you're saying, okay, well, I'm going to give away all power in this situation, but by doing so, I'm going to sweep the entire board to my side of the table.
It's kind of like sacrificing a pawn, right? To then go to checkmate.
Yeah.
It's like, all right, yeah, you take my pawn, I'll checkmate you, and if he moves after that.
Yeah, because what it would seem, if you're dealing with the actual principles of governance, okay, in a particular instance, the judge should be able to determine these kinds of things. But if it's going to actually be a matter of law, like long term, this then should be kicked over to the legislature. So this, kind of what Gopi was saying earlier, it's like, okay, well, yeah, the Congress is sort of the bad guy in this situation, but not for the reasons that he's articulating.
Yeah.
That it is Congress's responsibility to be able to actually be able to determine, as far as the law goes, what is constitutional and not. I mean, they're doing it every day when they're trying to make laws. But
Yeah, basically the judiciary can't be picking up the pieces for the legislature's incompetence. Like, if within a law, you have two lines that directly oppose one another, is it the job of the court now to come and fix that?
because this
Yeah.
is basically the crown jewel of precedents.
Yeah,
That's really what it is. So, I mean, there are obviously things that'll fall through the cracks.
Yep.
And that is the responsibility of the judge to determine what's fair in that particular instance. But it's also his responsibility to realize that what's right as far as governance concerns is that the laws should be made by a legislature and should actually be determined by the whole as far as laws usually go, and not through the circuitous route of, culture, basically, and then coming forward as the judge.
yeah,
And then, because in that situation, you're basically having culture determining directly what is law, which, much as we might like freedom, that the freedom that is, given to cultural initiatives, that's not really how law should work.
yeah. No, we have again, back to the system of checks and balances. There's so much to that for all these different places to check different places and do things. But yes, I'm always a big fan of returning to a strong system of checks and balances where the right things check the right things. And I actually believe a lot of it's possible to do. We just need to talk about it. We need to start pushing it, helping people see it, coming up with solutions, hearing other people's ideas, getting the good solutions together, because there are some really cool things that happen. But again, certainly thanks to those that came. I know it was smaller tonight. There was a lot of people that said they wanted to come, but apparently tonight was a popular night. So it was a significant number of people told me they had at least 3 things they were supposed to be at tonight on their schedule. So hopefully November 9th isn't as busy. We'll see. But whether it's small or big, I enjoy the discussions and hope you guys do too. And so you can certainly feel free to take a Believe wristband if you want. Don't have one. Again, if you want to know more about these, please do. We'd love for you to share them with people. I think when we get a good discussion going, it's a lot of fun. And then let me know if you want topics for next time. If not, we'll probably start with there's some really fun stuff to delve into with the executive and legislature, but we'll probably hold off on that for a little bit and start with freedom of speech, because there's some fascinating freedom of speech stuff. A lot going on with that in our country right now. A lot of fun things to talk about. So that will probably be our next one on the 9th, unless people have strong opinions on anything.
That sounds good.
So thank you.